In 2008, the Law Commission estimated that there are over 38 lakh check bounce cases in India, and in today's scenario, there are over 33 lakh check bounce cases, which is clogging our legal system. In this video, we will see what are the legal remedies that are available and at what circumstances one can initiate a check bounce case, basic ingredients of the check, and also right from issuing of the check till the conviction, what is the process that are followed in the present legal system. Knowing the basic things about the check, the main ingredients are name of the bearer of the check, date of the check, amount in words which should match with amount in numbers, personal signature or authorized signature, and name of the check issuer. Only with these ingredients it will be considered as the valid check. There are two basic types of check, uncrossed and crossed check. Uncrossed or open check is the check amount will be paid over the counter to the holder of the check. In crossed check, it will be deposited to the payee's bank account. One more important thing about crossed check is it cannot be negotiable by any person other than the payee. There are various reasons for the check bounce. Insufficient funds is one of the main reasons. That is when there is not enough balance in the drawee's bank account for the payment of the check. So the other reason is when the check is not presented within 3 months to the bank, then it will get expired. Then if any details of the check is overwritten, or if the check is damaged or disfigured so the details are not visible, or if the signature is mismatching with the bank's database, or if the amount in words or figures is mismatching, then the check shall bounce. Not for all these reasons one can seek a legal remedy. We will see in which scenario one can go for it. The very important thing which we have to note down here is the payee cannot complain if the check was issued as a gift or provided as a security to lend a loan or for any other unlawful purposes. Only when the payee given some debt if beforehand, and if the drawer in discharge of his liability of his debt issues a check, and if that check was dishonored due to insufficient funds, then only the payee can complain or he can seek a legal remedy, otherwise he cannot. So whenever a check bounces, there are three remedies available to the payee. The first one is he can resubmit or represent the dishonored check if he thinks the check will be honored the next time. It has to be presented within 3 months of the date specified on the check. The second remedy will be instituting a civil suit to recover the money. The civil suit will not punish the drawer, only the criminal complaint, which is the third remedy given to the judicial magistrate under section 138 of the Negotiable Instrument Act, will punish the drawer since due to insufficient funds the check is dishonored. So when a person thinks he wants both civil and criminal remedy, then he can very well go institute a civil suit and also the criminal complaint parallelly. The punishment for the dishonored check is imprisonment, which may extend to 2 years, or with fine, which may extend to twice the amount of the check, or with both. This is up to the discretion of the court. So we have seen so many reasons for the check bounce, but only when the drawer wantonly is not willing to pay to the payee for his debt, and because of insufficient funds, if the check is dishonored, then only this section 138 of Negotiable Instrument Act attracts. Then only the drawer will be prosecuted. There are certain conditions to be fulfilled to attract the section 138. First, the person who issues this check is liable to pay some amount to the payee. So in discharge of his liability, he should have drawn a check in the name of the payee. The next would be the payee will present the check to the bank within 3 months from the date of the check, or within the period of the validity, whichever is earlier. The next process is that if the drawee bank is unable to pay the amount due to insufficient funds, then it will send the check written memo to the payee's banker. So the payee's banker will forward that memo to the payee, informing that the check is dishonored due to insufficient funds. After receiving the check written memo from the bank, if the payee is willing to proceed legally, then he has to send the notice to the drawer within 30 days for the repayment of the check amount. The check bounce notice, which is issued by the advocate of the payee under section 138 of Negotiable Instrument Act, it will specify 15 days time to the drawer for the payment of the check amount. If he fails to pay within 15 days from the receipt of the notice, then the payee will get the right to file a criminal case against the drawer. The payee shall file a complaint before the judicial magistrate under section 138 of Negotiable Instrument Act after the expiry of 15 days of check bounce notice if the drawer fails to pay the amount. After receiving a complaint from the payee, the court will issue the summons to the drawer to appear before the court. The first step is the appearance of the accused before the court, and he may accept or deny the facts stated by the complainant. And if he refuses the allegations, then the court trial will commence. At any stage of the trial, the court may put 313 questioning to the accused to explain about his circumstances. The accused will file his statement and evidence, and also while examining the witnesses, the document will be marked as the exhibit, and from both the sides, the arguments will be presented to the court with the precedents. According to new section 143A, an interim compensation of maximum 20% of the check amount can be demanded by the complainant on the first appearance of the accused. If the accused is acquitted after the trial, then the complainant has to repay the interim compensation amount with interest rate prescribed by the RBI as directed by the court. So whatever we have discussed till now, the timeline at each stage is given here. You can pass it in, read it once again. If the complainant or the accused is not satisfied by the order, they can go for an appeal. And if it is a judicial magistrate order, they can go appeal before CJM, Chief Judicial Magistrate, or if it is a fast track court order, they can go before Session Judge or District Judge. The appellate court may direct the appellant to pay 20 to 30% as deposit for appeal admission, and direct arguments will be allowed based on the facts of the case. The appellate court either uphold or set aside the order passed by the lower court. That's all for today. Thank you for listening. Please share it if you find it useful, and also please provide any feedback in the comment section. Thank you so much.